Hi, welcome back. My name is Joe Peterson. I'm with the Castle Law Firm. Now, I was watching a lot of TV and movies recently, and just like you might have noticed that in some of these TV shows and movies, people say that they want to get a restraining order. And one of the main reasons that people want to get a restraining order is because somebody is just being very, very, very annoying. The way that they portray getting some of these restraining orders in TVs and movies is simply by going down to the courthouse, asking for one, and then all of a sudden, by magic, somebody has to stay 500 feet away from you. The reality is, in North Carolina, restraining orders as we may commonly think of them don't exist. There are some remedies that are available though. One of the most important ones is available under Chapter 50B of the North Carolina General Statutes, and it is called a Domestic Violence Protective Order, or DVPO for short. Domestic Violence Protective Orders require that there be a domestic relationship. A domestic relationship could include something such as husband and wife, or parent and child, or boyfriend and girlfriend. But the complete list may be available to you on our website at thecastlelawfirmonline.com. Now, if a person who is in a domestic relationship feels that they have been a victim of domestic violence, they may be entitled to a protective order. The statutory grounds for what domestic violence entails would be attempting to or intentionally causing bodily injury, placing the victim in fear of serious bodily injury, or any act within a parameter of North Carolina general statutes, which generally is a list of sex offenses. And so if a person feels that they are a victim of domestic violence, what they need to do is they need to go down to the courthouse and fill out one of these. This is a complaint for a domestic violence protective order. Now, if a judge feels that there is an emergency present, then a judge may issue an emergency ex parte order. The emergency ex parte order would only last up to 10 days until your court date. And that is the important thing to remember about a DVPO, is that it is a civil lawsuit at its heart. At your court date, you have to show up and prove to the judge by preponderance of the evidence that you are deserving of a protective order because you have been the victim of domestic violence. If the judge believes you and grants a 1-year domestic violence protective order, that will prevent the defendant from contacting you, harassing you, stalking you, abusing you, being in your presence in any way. Now, from the defendant's standpoint, it's very important to realize what contact means, because it can cover anything from a text message, a phone call, email, LinkedIn, Snapchat, carrier pigeon, I don't care. You can't contact the plaintiff. In fact, the plaintiff, the person who has the domestic violence protective order, can't even give you permission to violate the order. They can't text you and say, hey, can you call me? And that gives you permission to call them. It doesn't work like that. Now, some people who are the defendant in the DVPO case may think to themselves, I don't care. I don't want to talk to this person anyway. I'll just let the order go in place. That's a very dangerous thing to do, because in addition to not being able to contact that person whatsoever, you subject yourself to many other consequences. A crucial one being that you are not allowed to purchase, own, or possess a firearm of any kind. That includes ammunition. And that could be an especially big problem if you are employed through the armed services or with law enforcement, which could put your job in jeopardy. Another consequence of having a domestic violence protective order put against you is that if you violate it, you subject yourself to a potential motion to show cause, for which you could be held in civil or criminal contempt. And the worst one of them all, violation of a DVPO in North Carolina is punishable as a Class A1 misdemeanor, which is just one step below a felony. So, That is one form of restraining orders that are available in North Carolina. And it's very important to remember not to take these lightly. Whether you are a plaintiff who believes that you are the victim of domestic violence or a defendant facing accusations of domestic violence, a plaintiff should not file one of these complaints lightly, and a defendant should not take these accusations lightly either. Although restraining orders, as you may classically know them, do not exist in North Carolina, there are real remedies available for those who have unfortunately been victims of domestic violence. Now, you might be looking at me and saying, "But Joe, I don't have a domestic relationship with the person who is harassing me. My neighbor next door, they keep threatening me, throwing bags of dog poop into my yard, and yelling at me across the fence. How can I stop that if I'm not in a domestic relationship with them?" There are remedies available, and that is through a 50C no contact order, which I will further discuss in another video. Thank you for your time. If you have a question about a family law or criminal law related matter, please either comment below the video or send us an email at castlelawfirmqa@gmail.com. That's castlelawfirmqa@gmail.com. Thanks for watching.